Massachusetts is recognized for having some of the strongest consumer protection laws in the country, especially when it comes to safeguarding homeowners during construction, renovation, and home improvement projects. Two key statutes form the legal foundation for these protections. Massachusetts General Laws Chapter 93A, the Consumer Protection Act, and Massachusetts General Laws Chapter 142A, the Home Improvement Contractor, HIC Law. Together, these laws define how contractors must conduct business, from licensing and advertising to contract execution, cancellation rights, and dispute resolution. They also empower homeowners with robust enforcement tools, including the right to file formal complaints, pursue triple damages, and access the state's HIC Guarantee Fund if a contractor fails to fulfill their obligations.
In this section of this module, you'll learn what rights you have as a homeowner under each statute, and what contractors are legally required to do, and what constitutes a violation or deceptive practice, and what steps you can take to file a complaint, recover damages, or escalate enforcement if necessary. This law prohibits unfair and deceptive acts or practices in trade or commerce. Contractors who lie or mislead you, omit key facts, fail to disclose costs, or pressure you into making rushed decisions may be violating Chapter 93A. This law applies to both businesses and individuals who provide services, covers false advertising, bait-and-switch tactics, hidden fees, and non-disclosure of rights. It also allows private legal action by consumers harmed by unfair practices, and if the violation is found to be willful or knowing, courts may award triple damages and attorney's fees. An example of this case would be Commonwealth versus Dakotas from 1974, where the Massachusetts Supreme Judicial Court held that even an omission of material facts could constitute a deceptive act. This case set the foundation for 93A enforcement against contractors who withhold or conceal critical information from clients. Why this case matters for homeowners is because the court made it clear that a contractor doesn't have to lie to break the law. Leaving out important facts or charging for services not provided can also be illegal. Fees with no explanation or value may be considered deceptive. The law protects people in vulnerable situations, including seniors, people with disabilities, and lower-income households. The problem is that Mr. Dakotas ran a mobile home park and charged homeowners a resale fee every time someone sold their mobile home, even though he did not provide a service to earn that fee. The court's decision was to rule this was unfair and deceptive under Chapter 93A and ordered the money to be returned to homeowners. He was also barred from doing it again. And what it proves is you don't need a written lie to have a case. Charging for nothing or leaving out important details can still break the law. What you can learn from this case is you have the right to know what you're being charged for. If a contractor charges you for permits, fees, or services that were never completed or never existed, you may have a legal claim under Chapter 93A. Always ask for written estimates, copies of license numbers and HIC certificates of insurance, detailed receipts, proof of completed work, copies of permits, inspection reports. In this next section, we'll go over real-life scenarios where these contractors may deceive you and inherently violate Chapter 93A. These examples reflect the kinds of unfair or deceptive practices that courts and state agencies consider violations of your rights as a homeowner. Each situation involves either a misrepresentation, a hidden fee, or charging for services not provided. The exact behaviors that triggered action in Commonwealth v. Dakotas. Scenario 1. Fake rebates used to pressure a sale. This example would be when a contractor tells a homeowner they'll get a rebate if they sign the contract immediately, claiming it's a limited-time offer. The homeowner ends up signing under pressure. Later, they find out no such rebate exists, and the contractor refuses to honor the claim or revise the agreement. The violation would be considered deceptive inducement, luring a consumer into a contract with false promises, prohibited under MGL Chapter 93A. Scenario 2. Permit fee without a permit. This scenario would be a contractor includes a $1,000 permit fee in your invoice. Later, you learn no permit was ever pulled with your city or town. The violation is charging for a service that was never provided is an unfair trade practice. This mirrors the unlawful resale fee in Dakotas. Scenario 3. Cleanup fees, no cleanup. If your final invoice includes a $500 fee for site cleanup, but your property is left with construction debris, nails, and hazards, the violation would be billing for work not actually performed is a deceptive billing practice. The law protects you from paying for empty promises and services you did not receive. Scenario 4. Hidden administrative fees. Say you agree to a $12,000 kitchen remodel, and after work begins, the contractor adds a $1,200 administrative processing fee that was buried in small print and never explained verbally. The violation committed is the failure to clearly disclose all charges up front is considered an omission of material fact, which is deceptive under consumer law. Scenario 5. Prepaid materials that don't exist. Imagine you pay $5,000 upfront for custom windows, and the contractor claims they've been ordered, but provides no receipts and no delivery ever occurs. The violation is taking money for goods never ordered is both a Chapter 93A violation and potentially larceny by false pretenses under MGL Chapter 266, Section 91. Scenario 6. Falsifying labor hours. A contractor charges for 40 hours of labor in 1 week. You are home most of the week and know they were only on site for 6 to 8 hours. They are in violation by inflating labor hours, is a form of fraudulent billing, a deceptive practice that may be civilly or criminally actionable. Each of these examples demonstrates how the law protects you from contractors who lie or withhold critical information. Add hidden fees after work begins. Take payment for things they never deliver. You have the right to challenge these practices under Massachusetts consumer law. In many cases, courts can award triple damages and require contractors to pay your legal fees if you prove a willful violation.